The Electoral Amendment Bill is mostly aimed at expanding the Act to include independent candidates as contestants in elections in the National Assembly and provincial legislatures. Currently, independents can only contest at the local government level. The New Nation movement deemed this to be unconstitutional, and the Apex Court agreed. In June 2020, the Constitutional Court ruled that Parliament make the necessary changes by June 2022. The bill was introduced to Parliament by Home Affairs Minister Erin Motsoaledi in January 2022. The Portfolio Committee on Home Affairs received hundreds of written submissions and scores of oral submissions from individuals and organizations. Public hearings were also conducted across the country. This extensive public participation process soon made the committee realize it would not meet the deadline. It then approached the Concourt for a 6-month extension. This was granted until the 10th of December. Electoral reform has been an ongoing discussion in South Africa for many years. The Van Zyl-Slabbert report was commissioned by Cabinet in 2003 to look at this very issue. Government has previously been criticized for not taking the matter of electoral reform seriously enough. This was again raised in the committee when opposition parties asked why the Van Zyl-Slabbert report was left to gather dust and not have its recommendations implemented. But Minister Motsoaledi defended government's position. He said that report did not specifically deal with the issue of independence.
Van Zyl-Slabbert was looking for constituency system within the current system of political parties. If you read that report from Van Zyl-Slabbert, it's a 72-page document. In that 72-page, the word independent does not even appear once. It was not even considered. It does not even appear once. Nobody ever thought South Africa could have elections in the National Assembly and provincial legislatures where independents are taking place, are taking part.
He stressed the importance of broader electoral reform, saying it's an issue that needs to be dealt with. One of the ways in which Motsoaledi's department wants to send a signal about its commitment to electoral reform is with the provision of the establishment of a panel in the bill which will investigate what exactly is needed to reform the system and how it should be implemented. This clause was introduced to the NCOP's Select Committee on Security and Justice after the bill was passed by the National Assembly.
The objects of the panel are: 1, to independently investigate, consult on, report on, and make recommendations in respect of potential reforms of the electoral system. So the panel will be going and considering what potential reforms should be made.
The addition of this provision, as well as a further round of public hearings on the matter of how many signatures candidates need to be able to contest, are substantive proposals made by the NCOP and largely why the second request for an extension was made. Civil society organizations weighed in on this second request. The Council for the Advancement of the South African Constitution says this demonstrates how poorly Parliament has handled the process.
That Parliament has run this process very haphazardly. There hasn't been a proper public consultation process up until now. And even now, on the basis of this latest second extension of the deadline to the end of February 2023, given the December holidays, how adequate that time is going to be for proper public participation on some key changes that the National Council of Provinces has made to the draft Electoral Amendment Bill.
The Independent Candidate Association said civil society has lost faith that Parliament considers its recommendations with the seriousness it deserves. The association has, however, welcomed the extension, saying it places high value on public participation.
However, our organization will be applying to the courts, coming in either as amicus or as applicants in support of the respondents, that we would like a supervisory order adjacent to the extension with timelines, quality, and deadlines of what Parliament is expected to do.
Parliament requested an extension until the end of February, but the Court ruled the bill needs to be completed by the end of January. The Independent Electoral Commission says this relief by the Court will not hamper its preparations for the 2024 national elections.
We will be in a position to commence with preparatory work on the basis of what is currently in the bill. We do so on a risk basis, and we hope that the structural features of the bill would not change in the intervening period.
Meanwhile, the New Nation movement is challenging the proposed amendments, saying they have nothing to do with the original order.
What the NCOP, together with the National Assembly, have put together thus far is a far cry from the guidelines that the Constitutional Court had given. So we really feel that the National Assembly and the NCOP are just dilly-dallying and playing for time.
Mkhuliswa says they have been asked by Parliament to make submissions on their concerns about the proposed amendments. Abra Barbia, SABC News, Parliament.